Hello, and good morning, everybody. So here we are again for day 2. I haven't seen anything up yet. I will be checking and seeing what the news and everybody is saying. I'll bring it to you here, and then we are going to be in verdict watch. I do believe they're going to come back today. Hello, Hockey Mama. Good to see you. Hockey Mama says, I pray she's found not guilty, but I have a very weird feeling that something isn't right with the jurors they have picked. What is your feeling? Well, I know the 2 jurors that didn't get picked for jury that are in reserve, that are alternates. Both of them had very strong facial reactions to Proctor's testimony. So, was that set up that those 2 are the ones that were going to go because of them showing some kind of emotion when John Proctor testified? I don't know. Hockey Mama says this is close to us where we live and it's all corrupt. Yeah, I seen that. I've been watching. Like I said, I only came in on this about 2 weeks ago, I guess. I'm going to say 2 weeks. And I've been power watching everything that I could watch, some testimonies. A lot of my subscribers here have said, Willow, if you watch anything, you got to watch these ones. So I've tried to catch up. Now, did she hit him? I don't think so, you guys. I really don't. I'm not 100% saying she didn't do something in some fashion, but I don't think there's enough for me to say that she did it and that she did it intentionally. So I don't think the prosecution has proved its case. I'm going to say that with 100% certainty. I do not think that they proved that, number 1, she hit him. Number 2, that she intended to hit him, which they would need to prove for second degree, which she is charged with. I think they really overcharged her. Now, what I am concerned about, and I said this yesterday, is that the included charges. Was she drinking and driving, knowing that she could cause some other person harm? I mean, I think that is very wide open. Now, I didn't really catch all of the instruction on that, but I feel like it leaves that wide open. It wasn't specific enough. I think that I think there should have been an instruction that she would have had to know that she hit him and then left, because there's leaving the scene of an accident. There's, leaving a scene of the hit and run. There's all kinds of little things in there that she can be nailed on, even though I do not feel that the prosecution proved, number 1, that she did it. Number 2, and I'm going to show you something, you guys. There's a couple of things that I watched last night, which is true, because there's one cop that testified when he went to get Karen Reed's car, that there was only a piece of that tail light that was cracked and broken out, that the rest of the tail light was there. So why is now 99% of the tail light gone and found on the front lawn at 34 Fairview? When the officer that went to get her vehicle to grab it and put it in the Sally Port, whatever, said that there was only a crack and a small piece missing. We're going to go over that. I got some things to show you, which I found were very, very interesting. So we're going to get to that. You should watch the town hall Canton meetings, right? We may do that. Because I never did do a reading on this. I didn't even know about this case until a couple weeks ago. So Christine Isabel, good morning, my love. She says, I feel she did something, but prosecutors didn't have a solid case. Hockey Mama, what's very strange to me about it is the family brought other families to the closing arguments. Yeah. Yeah, I figured that was what you were trying to say, Christine. Yeah, it's a public courtroom. But I think from what I heard, because I asked this question yesterday, from what I heard is that Karen Reed and the defense team requested this specific courtroom. And I think they did because it wasn't a large courtroom, so there wouldn't be a lot of spectators. I don't think there's like the seating that you can see where you see John's family sitting and family and their supporters. That's one area. And there's the exact same size area behind Karen Reed, which half of it is reserved for her family. So if maybe 12 people, not even, maybe 3, 6, 9, maybe if 9 other people can get in, that's it. Yeah, I think Lally really dropped the ball on this. It was one of the worst cases that I've ever seen put on by the prosecution. And I have seen a lot of criminal trials. You guys know for 30 years, I worked in the criminal legal field. And I've never, well, I can't say I've never, I have seen other cases here in Canada that were really poorly presented. And I feel like Lally just wasn't the guy to present this case. And I think he fell real short. So I want to play this before we get going. We got about 5 minutes. There's parts of this that I want to play because I came across this last night. And then I want to ask you what your thoughts are on this because it really tells the story. Good morning, Vera. Good morning. Good morning. So let's go ahead and watch this. Yeah, I think they overcharged. Okay, so let's go ahead and watch this before. Oh, I got to get my earbud in. Hang on a sec. Turn off my volume here so you guys don't get feedback. Okay. Okay, so this is what I want to play. We're going to play bits and pieces of this, but this I found really, really interesting. And then we'll go ahead and we'll talk about this when we've watched this piece, okay? So here we go. Let me make sure the volume is up. Yes, okay.
After finding missing Boston police officer John O'Keefe's body laying nearly lifeless on the front lawn of 34 Fairview Road, a 911 call was placed by Jennifer McCabe at 6:04 a.m. Moments later, Canton police, fire and ambulance services arrived on scene to render aid to John O'Keefe. He was then transported to Good Samaritan Medical Center where he would later be pronounced dead. Once John O'Keefe left in the ambulance, responding veteran Canton police officers Lieutenant Paul Gallagher, Detective Sergeant Michael Lank, and Sergeant Sean Good began their investigation by searching for evidence. It was nearly sunrise, and the sky was getting brighter by the minute. The low wind, minimal snowfall.
See, this is what I wanted to see because there was minimal snowfall at this point. So I'm going to just back it up a couple seconds here. And then play it because they do say it.
It was nearly sunrise, and the sky was getting brighter by the minute. The low wind, minimal snowfall, and early morning sunlight provided the best conditions for a police search that would be possible for the next 24 hours. Since it had only been snowing lightly up until this point, and would not start snowing heavily for another 3.5 hours, Lieutenant Gallagher was able to clear about 2 inches of accumulated snow from the crime scene with a leaf blower.
And right there, it's like what? Anything that was inside that leaf blower could have contaminated the scene. So I find this very shoddy.
Before we go any further, let's discuss all of the evidence that was present at the crime scene that day during the morning Canton PD search and the evening Mass State Police search.
Okay, so what he's saying now is there was only a little bit of snow on the ground. So if there were big chunks of the red taillight, anything like that, they would have seen it. Okay. And I think this is really important because they find the glass and shards, every little shard of the white glass in this little bit of snow that's there, but they don't find these big red pieces on the first search when they found his body. Let's listen.
Search in total, according to the Commonwealth. 1 broken cocktail-style glass. 1 men's sports shoe belonging to John O'Keefe. John's cap. 6 blood samples collected from the snow using improvised red plastic cups borrowed from a neighbor. And 37 pieces of...
Okay, so they're telling you right now everything that was found come the end of this. But what he's going to tell you is the first search, you see how big this piece is? It's big. And all these pieces here are all bigger than the pieces from the white, clear glass, which would have been, the glass would have been very hard to find, you know, in the white snow because it's a clear glass. Red would be seen a lot easier. So would his shoe, so would his hat, etc. But they don't find his hat and they don't find any of these red pieces on the first search. Let's listen. I find this so interesting.
Shattered tail light plastic scattered across the crime scene. Now, envision all of that evidence on the grass surrounding John's lifeless body, precisely at the spot designated by the state of Massachusetts as the point where he came into contact with Karen Reed's taillight. This contact had such force that it resulted in the taillight explosively shattering into 37 pieces and the cocktail glass breaking. A violent impact of such magnitude that it not only knocked one of John's shoes off, but also sent his cap flying from his head. What was found by the Canton PD during the first search is quite curious. They were able to locate all of the broken cocktail glass pieces and all of the blood samples.
All of this clear glass they found when they did the initial search, when they found his body was taken away by the ambulance. They did say they found his phone underneath of him. But this is what they found when there was very minimal snow, okay? They collected some blood samples with these cups that they got off a neighbor. Totally shoddy, using a leaf blower, using these cups that are not sterile, nothing. It's bad, you guys. So listen to this carefully, what they found on the first search, and then when they found the red tail light and everything else, okay? Because I feel the first search, when there's very minimal snow, if they could find all those pieces of clear glass from that cup, why couldn't they see these bright red taillight pieces, some which were very large, right? And why could they see droplets of blood that they collected in unsterile solo cups from a neighbor? Let's listen.
However, of the 37 bright red tail light pieces laying in the pure white snow, they were able to find exactly 0.
See? Hello, Shellbell. Good morning.
The Canton PD's morning search had concluded as the case was being transferred to Detective Michael Proctor of the Massachusetts State Police. As the clock neared 10 a.m., the blizzard intensified dramatically, subjecting Canton to a relentless onslaught of 2 to 4 inches of snow per hour. Throughout the day, the Massachusetts State Police Special Emergency Response Team, also known as CERT, remained on standby, poised for the command to initiate their own investigation of the crime scene. They were acutely aware that each passing minute only added to the accumulation of snow on the ground and diminished the available daylight for their search. However, CERT team leader Kevin O'Hare received a call from State Police Lieutenant Brian Tully, stating he did not have authorization to start the search yet. The reason for this many hours-long delay remains unknown.
Interesting, eh? It's better. Okay, so from the time they found him in the morning, sunset at 4:55, they still didn't have a warrant to search. By the time they got the okay to go and search, the snow had piled up all day, and this is where Proctor was on the case. Okay, so we already heard when they found his body, they seen in the bright white snow, they found clear glass from the drinking glass, and they found some droplets of blood, which they picked up in red Solo cups after using a leaf blower, but they didn't see bright red taillights, broken pieces of taillights in the snow when there was only maybe an inch or so of snow. Bright red. They didn't see it, but they seen clear glass from the drinking glass. Now, they had the whole day. The snow's starting to pile up now. And guess what? Proctor's put on the case, and then guess what they end up finding? Let's listen. So this now is at 5:44 p.m.
At 4:55 p.m., the sun would set with nearly 21 inches of snow on the ground and more still falling from the sky, with no daylight, high winds, and at times blinding.
And also, they didn't see his shoe. Okay? In the morning when they got his body, like they didn't see his shoe. His shoe is bigger than even an inch. They would have seen that shoe. They would have seen all that red broken taillight. And his cap.
Whiteout conditions, visibility could not have been worse. Authorization would finally come. And at 5:44 p.m., the CERT team, along with State Police Detective Lieutenant Brian Tully, would conduct a second search of the crime scene outside 34 Fairview Road. There is no record of the area being cordoned off since the morning search, which left it wide open for anyone to access.
Okay, did you hear that? This scene was not protected all day long, not protected. Anybody could have went there and placed anything. No police presence, no nothing. It's very sneaky, very conspicuous.
Unmonitored until the state police arrived. Under these conditions, one wonders how they could have found anything at all. However, what the Massachusetts State Police claim.
They couldn't find these red pieces of the taillight when there was only an inch of freshly fallen snow, bright red taillight pieces, a whole bunch of them, some of them, this bigger pieces bigger than your hands. They couldn't find when there was only a little bit of snow. They leave the scene. By now, they've got the car. Okay, and then Proctor lied about when he got the car. And then all of a sudden, they come back in the dark, almost like 10 hours later. The scene's unprotected. 10 hours later, now there's 2.5 feet of snow. And this is when they find all them pieces? Let's listen.
Claim to have found is truly mystifying and challenges rationality. 20 inches more of snow, 40-mile-per-hour winds, and complete darkness. The state police claim to have found 2 bright red and 1 clear plastic pieces of shattered taillight, along with John's missing shoe.
Okay, let's stop right there. To me, this looks planted. If it happened when they said that it did, this is the actual photo. This is from the crime scene photos. It wouldn't be sticking up like that. That's one of the larger pieces. This looks like, look at all the snow around it. These divots and everything. That's not how snow falls on a flat surface. Believe me, I'm in Canada. I know snow. So you got a front lawn that's pretty much flat. This is not how you would have found that taillight piece. Unless there was already a couple of inches of snow. Somebody got her taillight and threw the pieces there. And then they wait, and hours later, once there's all kinds of snow. To me, this looks planted. It's not laying flat on the snow, which it would have been. This looks planted. You can tell by the areas around it that this is not how they found this. This did not fly there from any kind of accident.
Logic would dictate that a mix of evidence should have been found by both teams. However, the fact that the morning search found all of the cocktail glass pieces indicates they did a...
See? Clear glass. They found every single piece of this glass. There was like an inch of snow. Why didn't they see these big, huge red pieces if they could find clear glass pieces? And the area that they searched where they found this is where they found some of the red broken taillight, right? By the time they do the second search, Proctor had already gone and got her car and would have had time to plant this evidence from her taillight at the scene. If there would have been big chunks of red taillight there, they would have found it on the morning search when there was only like an inch of snow, lightly put snow there. If they could find this and then the red pieces were found around where they found this, no. That's why I'm saying this was planted.
Meticulous job searching the area. Then how in the world during their 2-hour search did they miss 37 pieces of bright red shattered taillight glass, including one corner piece the size of a small teacup? And furthermore, what explains the Massachusetts State Police's ability to find them during the second largest January storm ever recorded in the Boston area? Leslie, how was the shoe missed in a few inches of snow during the morning search?
Listen to this, you guys. This is what I'm talking about. Proctor lied his way through all of this. YouTuber, good morning. Yes, the FBI is now investigating. That's who hired those last 2 witnesses. Crazy Graham, good morning. Shell, yes. The dog was rehomed. And as they went to get certain people's phones, those phones all of a sudden disappeared. They rehomed the dog. They dug up and redid the basement floor and then sold the house. It's all But here's the missing time. Let's listen to this because this is really important. Because I think first thing in the morning, there's K. Mitch. K. Mitch, I got everything. I'm in the process, K. Mitch, of doing that diamond painting right now for you know who. And I got a bunch of other stuff I'm going to be including with it too. So anyway, let's get back to this. This is really important.
Proctor took a 30.5-mile drive to Karen Reed's parents' home in Dighton, Massachusetts. The stated purpose of their visit was interviewing Karen about what had occurred the evening prior. Excerpt from the Commonwealth Statement of Case, dated...
Okay, so here's where Proctor starts the lie. Here's where he starts the lie, right here. Okay? Let's listen. Because this time, keep in mind this time, this is what he put in his affidavit. Okay? That time's going to be important.
June 2022, and signed by Assistant District Attorney Adam C. Lally.
At approximately 4:30 p.m. on January 29th, troopers Buchanan and Proctor arrived at a residence in Dighton, Massachusetts, the home of the defendant's parents. Upon their arrival, they observed a large black Lexus SUV bearing registration 3G684, registered to the defendant, parked outside the garage door in the driveway to the home. The troopers observed the rear right passenger side taillight to be shattered and a large red piece of plastic to be missing from the taillight. The black...
Okay. But there was another cop that testified that when he seen the car, when he first seen the car, this is the officer that's with him. When he first sees the car, there's a crack with a small piece missing. But when when Proctor does his affidavit, he said there was a large piece missing. Okay. So this is when I feel he broke out the rest of that taillight and went and planted it after getting her car. Because you got one of the officers saying when they first seen the car, there was just a crack in the taillight and a small piece missing. Proctor, in his affidavit, says it was shattered and a large chunk was missing, a large chunk of it. So there's the first lie. The time that he was there, 4:30, he said, was the first lie. The second lie was what it looked like. He says shattered and a large piece missing. That's not what the other officer had said. The other officer said a crack and a small piece missing.
Lexus SUV was seized from the driveway of the defendant's parents' home in Dighton on January 29th as well. The vehicle was then transported via tow to the Canton Police Department.
If the troopers arrived at 4:30 p.m., interview Karen inside the home.
Okay, so see what Christine says here. The second officer with Proctor was from another city PD, not Canton. Exactly. And that officer said that all he seen was a crack in the taillight and a small piece missing. But when Proctor said he seen the car, it was shattered and there was a large piece missing. This is where it starts. Okay, so you see here, and Proctor says that he didn't pick up the car until 4:30. Okay, this is important because their next police search started at 5:44. So if they only picked up the car at 4:30, there wouldn't have been enough time for him to get back to 34 Fairview with those pieces he took off Karen's car and plant them. But only if this is the time he picked up the car. He didn't. He picked it up earlier than this. So when they present this and they say, well, we didn't have time to get back and plant it before the next search started, there's the second lie. Let's listen.
Tow her vehicle at 5:30 p.m. as claimed, and then drive 1 hour back to the Canton Police Department. It would be impossible for them to make it back before the 5:44 p.m. search begins, which means they would have no opportunity to plant the taillight fragments.
Okay, so I know this person is, hang on a sec. I know this person is very controversial. Some people like him, some people don't, but he uncovered something. Good morning, Sybil. Good morning, Sybil. He uncovers something that breaks this wide open. Let's listen.
On May 2nd, 2023, award-winning journalist Aidan Kearney from Turtle Boy Daily News would break a story that would profoundly shake the foundation of the case and cast doubt on the integrity of both the Massachusetts State Police and the Norfolk District Attorney's Office.
I feel if it wasn't for him, they may have got away with this. They may have got away with this, you guys, of framing her, because that's what I think they did. Let's listen.
Kearney reported the existence of time-stamped video footage from the Reeds' home, showing Karen's vehicle being towed at 4:12 p.m. And he would go on to report more evidence in the form of public records requests to the Dighton Police Department, ultimately proving that the troopers arrived at 3:27 p.m. and were gone by 4:17 p.m. This means...
See? They didn't arrive at 4:30. They arrived at 3:27 and they were gone by 4:17, which gave them more than enough time to get back after getting those tail light pieces, because they take her car They arrive at 3:27. By 4:17, they've got her car up on the tow truck, and they're out of there. They have more than enough time to get back with the taillight pieces and plant it before this 5:44 p.m. search. Why did he lie? He lied here saying they only got there at 4:30 and didn't leave until almost 5:30. So they wouldn't have had time to get back and plant any evidence. But he lied with the time that they got there and the time that they left, which gave him time to break out the rest of that taillight. Don't forget, the second officer that went there with Proctor to Karen Reed's parents' house said, and he wasn't from Canton PD, he was from another PD. He said when they got to her parents' place, he noticed her taillight was cracked and there was a small piece missing. So how in the hell did her whole taillight get smashed out and all those pieces found at this 5:44 p.m. search? Why did he lie about what time they were there? It gave him time. Once they confiscated her car, it gave him time to break out the rest of those pieces, go back to the scene, plant them, because the scene wasn't being, they had nobody at the scene. It wasn't protected. There was no tape up. Anybody could go by. And then all of a sudden, these pieces are found in 2.5 feet of snow, but they couldn't find these pieces when there was only like an inch of snow. It's not making sense, you guys. Here's the cover up. Here's where it started.
Trooper Proctor and the vehicle were unaccounted for a period of 1 hour and 18 minutes.
1 hour and 18 minutes. The car and Proctor were unaccounted for. What did he do in that time? He broke out the rest of that taillight. Let's back it up just a couple seconds so you can hear the whole thing again.
Proving that the troopers arrived at 3:27 p.m. and were gone by 4:17 p.m. This means Trooper Proctor and the vehicle were unaccounted for a period of 1 hour and 18 minutes, and that they had plenty of time to reach the crime scene before the 5:44 search began. And that they lied about the timeline on official court documents in a murder trial. Quoting Aidan Kearney, "What these people are doing is evil and tyrannical, and we will never stop exposing their lies until each and every person who helped cover up the murder of John O'Keefe is criminally charged." There are lingering questions. Why did the Massachusetts State Police decide to tow Karen's vehicle to the Canton Police Department, especially given that it was no longer an active Canton police investigation? After all.
Okay, so these are all other Sally ports that were around that they could have towed her car to. Canton police at this point were taken off the case. So why would they bring it from all the way up here, all the way back to Canton, when they could have brought it to any of these? Look at this one, how close it was. Even these, a lot closer. This one, a lot closer. They could have brought them to any of these places here, but they didn't. They brought it all the way back to Canton, who had been removed from the investigation. Why did Proctor want it back at Canton? Because he could manipulate things. This is where they turned the cameras. They turned the screenshot. But it takes manipulation to turn that camera when they have her car in the Sally Port. So when they present to the jury, it's like, look at, nobody went and touched her car on that side. Look at, you can clearly see the passenger side. Nobody went nowhere near it. It's because it was flipped. But what they forgot to do was flip the timestamp at the bottom. So somebody physically went in there and flipped that camera angle, like turned it. You know how you can turn it in editing, but they forgot to flip the timestamp. That's not just an error. Like sometimes when you're filming something, it's got you flipped. So your right hand's your left hand, your left hand's your right. It didn't just happen like that, because even the time stamp at the bottom would have been flipped too, but it wasn't. So that proves that somebody went in and flipped that picture. So the jury scene Nobody went along, well, made it look like nobody went to the passenger rear of that vehicle, when in fact what it showed was they were at the passenger rear of that vehicle, but in the photo that they had originally showed, it looked like they were at the rear of the driver's side because they flipped the picture. But the defense caught it. And when you flip that picture to the way it's supposed to be, they are clearly at the rear of the vehicle on the passenger side doing something. Is that when they broke off the rest of the taillight and then took off and went and planted it? I don't know. Let's continue. And why did they insist on bringing it here in a major snowstorm when they could have brought it to any one of these other places to keep it safe until it could be looked at? And Canton police was off the case. Hello, Risa. Let's continue. And then I'm going to go and check to see if anything is up yet. I don't think anything is up. Let me just check quick to make sure that nothing is up yet. I do believe hang on a sec. Okay, so they do have it up. The clock is up, so I will hear it, you guys, if a verdict does come in. Okay. I do have a poll up too. Also, you guys, please go and check that out. Please smash that like button. Let's get this out there that I am live with this, showing this so people can see what we're seeing. Maybe people that think, you know, oh no, like they're going to get it wrong if they say not guilty. Please hit that like button. It's free to do. Jump out of live chat. Go hit that like button. When you come back in, make sure you do have live chat selected at the top of your screen so you don't miss anything. Okay, so let's get back to this.
There were many state police facilities in the area that would have been easier to travel to during a historic winter storm. Could the reason have been that the Canton police station is located a mere 1.4 miles from the crime scene, and troopers Proctor and Buchanan had a small closing window of time to get there before the evening search commenced? And as first reported by Turtleboy Daily News, why, in a recent court document, has the Commonwealth discreetly revised their timeline of these events, over a year after they were affirmed as factual by Assistant District Attorney Adam Lally and District Attorney Michael W. Morrissey? Why didn't Lucky see a body on the lawn? Why was the forward edge?
Don't forget, when the snowplow first went by, there was only like maybe a half an inch of snow. If there was a body there, he would have seen it. You see how that lit up? Look at. See how that lights up? He was found right here. That snowplow, look at the lights on the snowplow. That snowplow driver would have seen a body laying there. Look at, you can see right almost down to the ground here. There was a body there that is what? He was 200 something pounds, a good 6 to 8 inches thick minimum. He would have seen him laying there.
Why didn't Lucky see a body on the lawn? Why was the forward edge parked in front of the crime scene for over an hour at 2:30 a.m.? Why did Jennifer McCabe Google how long to die in cold at 2:27 a.m.? Where is all the missing evidence? Why weren't all of the people present in the house that night interviewed, and why was it never served? With Aidan Kearney's investigative work exposing the inconsistencies and misdeeds surrounding the case, the truth has become increasingly undeniable. The legacy of Officer John O'Keefe has become a symbol of the enduring pursuit of truth and justice, and his memory serves as a reminder of the power of interested citizens, coupled with relentless investigative journalism.
So that's that one. That's what I wanted to show you guys. Like, I know a lot of people don't like Turtle Boy, whatever, but he uncovered that and brought it to the forefront. Thank you, Risa, for hitting the like and taking the poll. Real Angel Girl, hello, good morning, and welcome everybody. Okay, so let's get rid of that, and I'm going to bring this over here. Get rid of this. Okay, I'm going to put this up. Okay, so there, oh. Well, we can see that it's been 3 hours and 9 minutes, and it's just the seconds that are blocked with my emblem there for some of you. Okay, let me get this. All right. Okay, so we got it up on screen, you guys. When they come in, I don't know exactly when they're going to come in. Let's see. I don't think, oh, let's go back and see here. Okay, let's go back to here.
Has anyone since we left the courtroom yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? Everyone said no or shook their hands. All right, with that, we'll send you back out to deliberate. Thank you.
All right, jury up, your call.
So this is this morning. They came into the courtroom and they're being sent back out to deliberate. There is John O'Keefe's brother. This guy right here is John's brother.
Make it seated.
All right, so counsel, I don't want the jury to have to wait for us for anything today. So you're to stay in the building until 10. I need you back here for the afternoon, no later than 3:30. And you'll be free to leave during the day as long as you can definitely be in here, in your seats, ready to go on 5 minutes notice, okay? So we'll see you then.
All rise for the court.
5 minutes notice.
You are
Minutes
muted.
notice, you guys. Okay, so there's been nothing since then. Okay. Whoop.
All right, thank you. We will send it back in with you, Officer Delano.
Hang on. What happened here? What happened?
On 22117, I believe we have a question from the jury.
Yes, it's
Question from the
simply,
jury.
good morning. The jury is kindly requesting to conclude deliberations in time to board the bus at 4 p.m. A juror has a long existing scheduling conflict. So I'm just going to simply say yes and send it back.
Yes, no objection.
That's fine, Your Honor.
Okay. Thank you.
So they'll only be deliberating until 4 o'clock today if they need it, because the juror has to be out of there by 4.
All right, can we,
What you can notice here is where are the Alberts today? Where's the Alberts? They're not there. Okay, so this was a jury question. The one juror has a scheduled appointment, so she has to be out of there by 4. So they'll only be deliberating till 4 p.m. today, if they even deliberate that long.
This, please.
Triple P for identification.
Thank you. Do you want the envelope? All right, thank you. We will send it back in with you, Officer Delano. Thank you. All right, all set?
All rise, please.
Okay, so that was a juror question. And there's been nothing since. Okay. They don't have the juror clock back up there, you guys. But so far at 9:30 this morning, they'd been deliberating for 3 hours and 6 minutes. Let me just write that down in case they don't put that clock back up. Oops. Okay, I got that written down so we can keep track of it ourselves. Okay, so that's that. So what I'm going to do is, hang on a sec. I'm going to put this up, and I am going to keep, let me just, one sec, you guys. Just put it here. Okay. So what I am going to do is keep this up, and as soon as I hear something come up, I will be letting you guys know. So keep your sound on. When you hear me come back, that means that we've got something. I'm also going to be keeping an eye out in other places because sometimes we get an advance notice. Let me bring that up right now. Okay. So I'm going to keep that up, you guys. And as soon as I hear anything, it will be back up on screen. If the jury has any more questions or the verdict comes in, you will see it pop up on my screen right here. I will be listening for it. I've got my earpiece in now so I can bebop around my house here, get some stuff done that I need to get done. The construction guys need to get into my house today because they're changing all the gas lines and the gas line that comes into the house. So they're going to be changing that too. They're changing my gas meter and everything, for those of you who don't know. So if you hear all this noise in the background, you guys, that is the construction guys. They're ripping up my whole street. They're replacing all the gas lines and sewers and water lines and everything on the street. So this is going to be going on until October. But today they are at my house now. They did next door yesterday. They're at my house now, and they're going to be digging up my gas line and replacing my gas line that comes in to my house all the way out to where it connects to the street. They've already replaced the gas lines that are buried beneath the property out there, I guess, whatever you want to say. So there is going to be a little bit of noise in that here today. So I am going to mute. And like I said, as soon as I hear it, I've got my earpiece in. As soon as I hear anything coming about, I will be jumping back on here and bringing it to you guys live. So I will see you guys in a little bit. If there's any jury questions, I'll also do that. Juror 11, I have no idea where Juror 11 is. Right? Oh, they've been working at this for the last couple of weeks, digging up everything and whatnot. My street was slated to be done this summer, so my whole street is going to be dug up, you guys. I don't even know how I'm going to get in and out of my driveway, but that's another problem for another day. Okay, I will see you guys as soon as anything comes about. Hopefully we get a verdict today. Cross your fingers. That's done. Okay. So feel free to chat, you guys, during this, but please be respectful. Mask any words that need to be masked. You guys know the drill. There are mods here to keep an eye on things or to answer some questions if you guys have any questions. All I ask, we can have differences of opinions, but please be respectful. Okay? I will see you guys in a bit.
hierarchy of the superior charge. And that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty. And on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Mr. Yannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't really.
Have you had no lesser includeds?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option for the rest.
Okay. I disagree with you. All right.
I don't see
Excuse me. This is funny, Ms. Reed. All right. We're done.
All rise for the court, please.
Okay, sorry about that, guys. I'm gonna be away. I'm gonna leave it on like this in case anything else comes up. I don't know what was just happened. I happened to catch it through my window when I was outside. But I got to go and check my security cameras. As you can hear, there's construction going on outside my office window here. They're cutting up the road and the sidewalk. But they had one of their diggers stolen this weekend, so they want me to check my security cameras. So I'm going to go upstairs and check that. First check was not guilty. I get his argument, but I also get the judge saying that. Okay, so give me a few minutes, you guys, and then I will be back. I'm going to have to rewind on my phone or something and check and find out what that was all about. Okay, I'll be right back. Oh, the first check was not guilty. I get his argument, but I also get the judge. Okay, wait, let's see here. They were saying there isn't a clear not guilty check on the jury form. Oh. Okay, so they're getting close to a decision. Okay, let me go upstairs and get this done, you guys. I'll be back down in a few minutes. And it's really loud here right now, so give me a couple minutes and I'll be back. Hey, sorry about that, guys. I had to catch a thief on my camera for these construction guys. Somebody literally pulled up with a truck and a trailer and took one of their backhoes and loaded it up on Saturday and took off with it. It's crazy. It's crazy. I'm telling you. Okay, I didn't watch all the jury instructions. Did she go over how to fill out the forms? Normally, yes, she did. Let's see. I haven't had a chance to watch it yet, you guys, so tell me what happened. Because, like I said, I was out there dealing with the gas company. And then they said, oh my God, you got cameras outside. We got a piece of equipment stolen. So I'm going to scroll back. I didn't watch it yesterday, but I'm sure she did. Yes, she did give them instructions. So they've been deliberating for 4 hours, because at 9:25 a.m. this morning, they were at 3 hours and 6 minutes. They'd been deliberating. And now it's 10:45. So add another hour and 15, 20 minutes to that. So 4 hours and 26 minutes. They've been deliberating. If I find out, she just needs to check the not guilty box. He wants not guilty available under manslaughter. Yeah, if there's a manslaughter charge, or like there's a couple of different charges they could charge her with if they don't get her on second degree. And there should be a guilty or not guilty on that form too. So not guilty is not on the verdict slip for manslaughter? What is going on? They were saying there isn't a clear not guilty check on the jury form. Jackson said, okay, let's go back and see. I want to hear this exchange. Sorry, you guys, but where is it? Oh, is this it here? Okay, let's listen to it again, you guys, because I was dealing with the gas company. They had a piece of machinery, a digger, that was stolen over the weekend, so I had to go and check my security cameras. Go figure, I missed everything. Okay, let's listen to it.
Why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments the court indicated it would make them.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
What you said before you were tired and you needed to think about it was you agreed that there needs to be not guilty options for subordinate charges under count 2.
I said that it made sense to me, but no, I did not change it upon looking at it, because the verdict slip, this verdict slip as submitted to the jury, is exactly how it always is in Massachusetts.
I ask you a question. I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Different things.
It's appropriate.
Let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge. And that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty. And on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Ms. Giannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't really.
Have you had no lesser includeds?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option for the rest.
Okay. I disagree with you. All right.
I don't see
Excuse me. This is funny, Ms. Reed. All right. We're done.
All rise for the court, please.
Oh, wow. Okay. So I get it now. So I get what he's saying, you guys. Let me just make sure I'm right at the end here. I get what he's saying. There is a not guilty box right at the top of the form. Now, there's 3 different charges underneath that they could find her guilty of. So if they check the not guilty at the very top of that form, they're saying she's not guilty for any of those 3 beneath. If that not guilty is not checked, then they would have to check one of the boxes down below to say which one they feel she's guilty of. I do too. I think each block, each one of those, because there's 3 charges underneath. Hang on, I'm going to show you. Hang on. Okay, oh God, I got to get my camera back up. Hang on a sec, you guys. Okay, stop sharing here. Let me put my camera on. Okay, so what they're saying, I know I've got my painting here and I've got it covered because this is a painting I'm doing for somebody. If Kay Mitch is in the room, she knows what this painting is going to be, who it's for. Okay, so here's the 3 lesser, okay? There's 1, 2, 3. There's a box, no, there'd be a box here, a box here, and a box here. At the top, there's a box that says not guilty. Okay, so this is manslaughter, whatever. I don't know what's on it, manslaughter. There's another charge here, say second choice. And there's a 3rd choice. So this is, here would be guilty, guilty, guilty. Okay, so up at the top, this is other and or included. Okay, so if they find her not guilty of second-degree murder, right? They can say manslaughter. Let me take this out because it's bothering me. Manslaughter, go through the thing for manslaughter. No, not guilty. So they wouldn't check that box. The second choice they have, like leaving the scene of an accident, blah, blah, blah. Is she guilty of that? They could check that box. This, is she guilty of this? If they find she's guilty of the third choice, they would check the guilty. If they find she's guilty of the second one also, so if they find she's guilty of any one of these, they would check this box. But if they find she's not guilty of any of these, they would check this box here. What the defense is saying is there should be two boxes here. There should be a guilty or a not guilty. That's what he's saying. There's only a guilty box here. So instead of just having the not guilty of any of these three and selecting this at the top, he says, I want a guilty and not guilty for each one here. And there's only a guilty box here. So, I mean, I get it. If I was on the jury, if there's only a guilty, if this is the only not guilty box on the whole form for other or included charges, if I read manslaughter and I read the instructions for manslaughter, and if I find she's guilty, I would check it. I go to the second one, whatever this second choice is, I forget what it is. And I would read the instructions for, is she guilty of this second charge? If she is, I would say guilty. The third choice, if I find she was guilty, I would say guilty. And this box would not be checked. This box would still be empty. But what I'm concerned about is, say, okay, here's your three guilty boxes, right? I know what he's saying. He wants this not guilty box down here. And there should be one for each one. So say I only found her guilty of the third included or other. So she's not guilty on, or even if she's guilty on, if they find that she's guilty on the second-degree murder, even if they say that she's guilty, they could also include one of these two, or they could leave these three blank and check not guilty. If they find her not guilty on the second-degree murder, they would check not guilty, second-degree murder, but then they could still choose one of these and this would be left blank. But if they don't find she's guilty, if they say not guilty on second degree, not guilty on manslaughter, not guilty on these three, then they would check this not guilty box at the top. But I get it that the defense also wants, instead of just a guilty box for manslaughter, they want this second box for not guilty. And there should be one here, not guilty, and there should be one here, not guilty, as well as the guilty box. So I get what he is saying. So if they do want to find her guilty of one of these, they just wouldn't check this not guilty at the top, and they would check which one they find she's guilty of. They could check all three. They could check one. So I get it, but I still say there should be a not guilty box here, here, and here, instead of just one at the top. You know what I mean? Or these should be each on their own jury form. There should be three forms here with a not guilty at the top or a guilty box beside. You know what I mean? Either put them on three separate forms so they have a choice to put not guilty for each one of these, or add the not guilty box along with the guilty box beside each of these three choices they have on the one form, instead of just having the not guilty at the top. So that's what I'm saying that they're arguing about. I could be wrong, but I don't think so. Okay, so let me get this back up on screen for you guys. So that's what I believe is happening. Now, the jury hasn't asked about that. That was the defense attorneys that came in and asked about that. So, are the juries going to understand? Is the jurors going to understand it? I think it could be confusing with just the one not guilty at the top of the form. But if they want to find her guilty of any of those three included, then they would just check the guilty box beside one of those three options or all three. If they find her not guilty, they just check at the top of the form, the not guilty at the very top, and that's not guilty on all three. I mean, you want to make it like I said, I worked in the legal justice system in criminal law for over 30 years, so I get it. But these people, I don't believe any of them have ever worked in the legal field. Are they going to understand it the way it's presented? Yes, every charge should have its own guilty or not guilty box beside it. They can ask the judge for that if they find it confusing. So say they don't find her guilty on, like they have three other options, right? So out of those three other options, say they only find her guilty of one, of drinking and driving with, knowing that she could hurt somebody. If they check guilty beside that, then the not guilty at the top would remain empty. But as long as the other two are not checked, she would only be guilty of the one that they checked. But I do agree that it can be very confusing, and I think that they should make it as easy as they can for the jury. I think each one of those added ones that they could charge her with, if they found her guilty of it, should have been on its own form. Mitch says it's about time she called Karen Reed. Yeah, but really right now it doesn't matter. She can say whatever she wants to Karen Reed right now because the jury isn't there, right? So they can't even say like you're prejudiced against my client. I don't know. Was it good of her to do that? No. I just hope they understand, and if they don't understand that form, then I hope that they ask the judge. So now I understand what's going on there. So we are back to waiting, you guys. Let me just see what is being said. Over here. So Alan Jackson was claiming, that's the defense attorney, he was claiming that the jury instructions weren't drafted in the way that the judge agreed to yesterday. And the judge is kind of like saying, no, I didn't say that. I said I'd sleep on it. And I don't believe that that's what it was. I'd have to go back and watch it. But I don't believe that that was the point that she said that she would sleep on it. So it says there's a guilty and not guilty option for the main charge, but there is no not guilty option for the lesser or included offenses. And people are outraged by it. just want to see what everybody's saying about it. One of the reporters is saying Alan Jackson was educating the judge on civil rights. But you know, she's tired and stuff. She's tired. Dog Mom, no, I had not done. I only found out about this case like 2 weeks ago. So I haven't done a read on it, but I may do one once the verdict comes in. I may do one. Yeah, it's been a bizarre trial. Let me just see what else I can find here, you guys. Sorry for the noise outside, you guys, if you can hear it. Okay, let's see. Okay, so there's manslaughter is one of them. Let me just write this down. DUI and vehicular manslaughter. Okay. Hmm. I know everybody is saying, I'm kind of worried about, and I said this yesterday when the judge was reading out these lesser or included charges, that's where I was a little worried because of the charges she included, like the DUI and stuff. Of course she was drinking and driving. Like she's trying to get at least a guilty on something. Good morning, Gina. Good morning, Marie. No verdict yet, but there's been some fireworks in the courtroom. You might want to rewind it a little bit. A lot of people are asking if the defense and that got to see those alternate jurors being selected, because they're saying that the two that were dismissed were obvious a not guilty vote, and by far the most attentive jurors the entire trial. No, I'm good, Marie. I've got so much going on. I just had the gas company. I had to go and move some of my stuff because they're changing all my gas lines to the house and everything. And then I had to go and check all my security cameras because over the weekend, the construction guys had one of their cobalt diggers or whatever it was, stolen. And some guy drove up with a truck and trailer and put that thing on the back of their trailer and took off with it. So it was stolen. It's like a $40,000 piece of equipment. So I've been running up and down and all over the place trying to get that and trying to do this, and I missed the outbreak there because of the jury forum, so I had to replay that. So I'm just trying to get everything caught up here. And now I'm just looking. Let's see. I'm trying to find the best. Oops. Okay, here we go. Okay, so I guess this is going to be the best one to watch. Because I think we'll be made aware, I don't know. I don't know, you guys, this is getting crazy. So we're on verdict watch. I've got the court feed up. Yeah, at the beginning, Marie, there's I do go through a video that I found, like a reconstruction video right at the beginning when we started this morning. You might want to go and check that out. It's pretty cool. It really explains a lot. Okay, I just messed up my. Just ignore me, you guys. I'm just trying to fix something I just messed up here. Trying to do too many things at once. Okay, so I'm going to leave this up. If I do hear anything start, I will jump back on. Oh, it looks like the camera is moving. I do think that we're going to have a verdict today, though, you guys. I just seen the camera moving, so it's been almost 5 hours. Oh, the camera's moving, you guys. I wanted to go and make myself a coffee, but I see the camera moving. In another 10 minutes, it will be 5 hours. So it's been 4 hours and 50 minutes that they've been deliberating. Okay, I'm going to take my earbud out, you guys. I'm going to turn up my volume, but I'm going to mute. And I'm sorry, you guys. Let me get my thing up. I don't know if any of you guys put super chats or anything. I haven't been here, basically. I've been dealing with the gas company, so let me just go and check and see if there's been any so I can thank yous. I can't get it up. So if there has been any super chats, super thanks, anything like that, you guys, thank you. I can't get my studio up for, it's probably because I've got the other window open. But we're seeing the poll that I do have up. We've got 86 votes so far. 15% think guilty, 71% say not guilty, 8% guilty of one of the lesser charges, manslaughter, and 6% so far are saying hung jury. So if you haven't voted, please click on the poll. And when you come back into chat, make sure you have live chat selected at the top of your screen. And also, please hit that like button. It helps get us out there in the algorithm. Okay, so I'm going to mute. Risa, they must have missed something because this morning when we started at 9:25 a.m., it was 3 hours and 6 minutes on the clock at 9:25 this morning. That's almost 2 hours ago. So it's like, it's going to be 5 hours and 6 minutes at 25 after 11, because you just add 2 hours to that. So 9:25 a.m. this morning, they said that they'd been deliberating 3 hours and 6 minutes. So at 11:25, it'll be 5 hours and 6 minutes. Okay, I'm going to mute you guys. I'm going to go quick and make a coffee. But I will be here lurking. I'm doing some stuff in my living room here. I have to stay near the door because the gas company has to keep coming in and out, so I am going to mute. But as soon as I hear something, I will run back to the computer if I'm not sitting here already. Reese says they didn't add yesterday's time. That was from yesterday's time because they didn't, they weren't deliberating for 3 hours this morning. They only started at 9. So at 9:25, the clock said they had been deliberating for 3 hours and 6 minutes. They haven't even been deliberating 3 hours this morning. They've only been deliberating like since 9:30, I think. So only 2 hours this morning and an hour and something from yesterday. Okay, I'm going to mute you guys. I'm going to go make a coffee and keep an eye for these guys having to come in because they're changing my gas line inside my house and that too. So I will jump on here if anything happens. I stuck around for a little bit because I seen the camera moving, but I've got my volume on. I will hear it. So have no fear. Please keep it classy and nice in chat. Oh boy, here we go, you guys.
Goes back to session, you may be seated.
Judge, we have a question for the jury. It's been marked QQQ for
Okay.
identification.
So, question, can we request the cert report detailing the search performed? So they can request it, but they can't get it. So I'm just going to say you have all the evidence in this case. We'll figure that out. I'll get some language from you. But Mr. Jackson, after our hearing this morning, I considered what you said. I went back and I read the jury instructions I gave yesterday. So I do appreciate the concern about the confusion this might cause the jury. I think it's easily clarified with the supplemental instruction. I don't think it's the verdict slip. I think it's how they're to follow the verdict slip. So what I've written up, this is a very rough draft. I'll read it to you. I'll
Oh, change your heart.
take a break and
Judge.
let you consider it if you want. And this works out. I received this, I don't know, 15 minutes ago, and I've been the letter, the question from the jury. So it seems a good time. So I was working on this. It seems a good time to bring them in for an answer to that question. And I would say, as long as I have you here, I want to clarify my instructions regarding your verdict as to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony, OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor. And if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. The lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proved all 5 elements, or proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony, OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all elements of manslaughter while operating a motor vehicle under the influence of liquor, and has failed to prove all of the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2.
May I have just a moment?
Yes.
Thank you, Your Honor. May I be heard?
Yes.
I deeply appreciate the court's additional clarifying language. I would simply ask for one very simple amendment, and that is at the top of the verdict slip, it says the 2 words, not guilty. We would ask that the verdict slip read, not guilty of the offense charged or any lesser included offense. That's it. And I think that and the court's clarifying instruction would satisfy the defense. That's all I think. I know it. That's all we ask.
All right.
I can repeat that if the court wishes.
So there are some like minor changes we have to make to the verdict slip anyway, just, it has to be consistent. So the manslaughter while operating a motor vehicle under the influence, the tab needs to, actually, Tori. So there needs to be some physical changes on the verdict slip. Anyway, it needs to be indented. There needs to be a colon after guilty of offense charged. It's not complete. It doesn't have under the influence of liquor. It just says under the influence. So there are some minor changes that need to be made to the verdict slip. Does the Commonwealth oppose the suggestion made by Mr. Jackson, which seems like a reasonable one?
No, Your Honor.
All right, so it will be not guilty. So tell me again how you want it.
Sure.
You want-
Not guilty of the offense charged or any lesser included offense.
Wow. So they're getting what they want. And
I think the clarifying language that I proposed
I
think that's fair.
is important.
I do too, and I appreciate that. I think with that amendment to the slip and the clarifying language, I think coupling those up is exactly what the defense was asking for. I appreciate that.
So I need to clean, I'd like to send in a written copy of what I just read there. I have a couple of things bolded. I need to fix this up a little bit. I mean, it was just done quickly. The jury's been waiting. Why don't we bring them in? And I will tell them that a new verdict slip will come into them. How's that? I do, though, have to make a finding that the verdict slip as is was proper. All right, so we'll just leave it at that. I'll make the amendment that you want, but that's my finding.
Thank you, Your Honor. Just from a logistics standpoint, once the new verdict slip is prepared and ready,
We all need to see it.
I was just gonna ask, do we have that email to us or something?
Yeah, we all need to see it. I will work with Tori. All right. All right, can we bring the jurors in, please? Oh, I'm sorry. What suggested language on the cert report?
I'm sorry, Judge.
Any suggested language on their question?
No, I think the court's correct that in terms of the cert report request, the court's answer is right on point, which is you are directed to you're directed to review the evidence that's in front of you, and that's it.
I'm just going to say you have all the evidence in this case. We will not give you anything. Okay.
Ooh, it looks like Karen is not happy with something. So I think what they're going to do to amend the form is fair. It's still, to me, I think, very confusing, a lot of the included. I still say it's very confusing for people who don't understand the legal system, how it works, and why certain words have got to be in there, but it is what it is. It's better than what they had.
All right, so jurors, we're in receipt of your question. Can we request the cert report detailing the search performed? I take this as a request, and the answer is that you folks, you have all the evidence in the case. So what you have is the evidence in the case. You won't be receiving any additional evidence. But as long as I have you here, I want to clarify my instructions regarding your verdict is to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor. And if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. So the lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony, OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all the elements of manslaughter while operating a motor vehicle under the influence of liquor and has failed to prove all the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2. So I'm going to send in a new verdict slip on count 2 that's just a little bit different, and we have to sort of change the we have to indent something and change the spacing a little bit to make it a little bit clearer for you. Okay, so we'll get that into you in the next 10 minutes. All right, thank you all very much. Jimmy.
Court will be recessed.
Okay, so there we got it. So they got a little bit of a win there. Let's hope that the jury doesn't get lost in all the wording. That's my only concern. So we will be here watching again, you guys, and we will be bringing it to you as it happens. Let's hope that there is a verdict shortly. Risa says, I love that she took a listen to what he said. Yes. Okay, I'm going to mute again, you guys. No, they changed the wording to include where they must choose not guilty if they haven't proven all the facts of the manslaughter. So that was added in. There is another box that will be added in there, and it satisfies the defense now regarding that jury form. The other thing was that they said that they wanted some celebrate report of some kind, and the judge said that what they have in there is what they're getting. She's not going to be giving any additional celebrate reports. So just they have everything that they are entitled to have in the jury room, and they would not be getting any other evidence that was presented. So there must have been some kind of issue with that certain celebrate report or whatever. But the judge said you have all the information that was given in the case, and that's what you got to make your decision on. She wasn't going to provide anything more. Okay, I'm going to be muting again, and This is going to stay up on screen, so as soon as something comes back, we will hear it. Yes, it was something with the Celebrate report, K-Mitch, that they wanted a report on, and the judge came back and said that they have all the information from the evidence already back there, so they weren't gonna give them anything more. But there was something that they wanted on a Celebrate report. I hear some noise in the courtroom, you guys, so I don't know what's going on there, but just to let you know, I did just hear some noise in there.
Can you hear for secretary? Can you hear? Yeah.
Okay, we got something going on here. I don't know if they just forgot to turn off the mics or they're coming back with something. It seems to me that there may have been just a mic that was left on. I know they're scrambling right now to get the new verdict form done. No, it was something with the Celebrate, they said. I'm almost sure they said Celebrate. I could be wrong, but I'm almost positive they said Celebrate report. Gina, Willow, I know you're in Canada, but is it allowed for prosecution witnesses to be in court for closing? Yes. They're allowed, once they testify, unless they're going to be called back, they are allowed to sit in the courtroom and watch the rest of the proceedings. That's Canada and the US. Once you have testified, you are free to sit in the courtroom if you are not going to be called again by the prosecution or the defense. So the only time you would still be bound by that order is if you were going to be recalled. So if, once they've testified and, the judges said, okay, you're not going to be recalled, you're freed from your subpoena, then yes, they can sit in the courtroom. And that's both in Canada and the US. So there's, like I said, there's some laws that are the same and some that are different between Canada and the US, but there is a lot that is the same, and that is the same in both countries. You're very welcome, Gina. Risha said she's seen CERT. It could very well have been the CERT report, but I thought that it was a Celebrate that they asked about. Don't mind me, you guys. I'm just doing something here as we are waiting. Keeping my mind occupied here. Until I gotta let these guys in the house again, or until a verdict comes in, and I'm hoping for a verdict today. What has me wondering, though, is the judge said that they had to end at 4 today because one of the jurors had an appointment that they couldn't miss. I wonder how that is, because they're sequestered, right? So I'm wondering if this woman or man, whoever the juror is, has to have a sheriff with them going on their appointment, because they are supposed to be sequestered, right? So that's interesting. I gotta stop messing with this. Am I chain smoking? No, I'm doing a diamond. You know what diamond painting I'm doing, K. Mitch. So the clickety click that you hear is me trying to straighten out some of these diamonds that I got OCD. So I see one out of place, I got to straighten it. So that's what I'm doing right now. No, I've been doing really good with the smoking things, so I'm proud of myself. I'm not quite quit yet, but I am proud of myself. See, I can show you. Hang on a sec. Let me put my cam, and I'll do this. See, that's what I was doing. This is what you just heard me doing. I was doing this with my straightener to get these all straight. So that's what you heard me do. Oh, it looks horrible there. But these are all different colors on the top here. But anyway, that's what I was doing. See, you can see some of these spots here where they're not quite straight. So that's what I've been doing, is trying to get these spaces in between as even as I can. You don't see it. Like once the light is out, you don't see it. But I see it, so it's still driving me nuts. I still got a lot more to do here. Like this isn't done. There's some over here, but I want to try to get them as straight as I can. So that's what I'm doing. I am not smoking. Oh, I'm trying hard. I'm getting there. So that's why, like, I whip out these paintings like you wouldn't believe. Like, I showed you guys the one that I was working on just the other day. Hang on, let me grab it because I'm done it now. This is a lot bigger one. So here, I'll start my camera again. Here. So this is the other one. This is the one I just finished. And this is a 50 by 40. I just finished this one. You can't see it because the court thing, but this is the one that I just finished. And I do this because it keeps my hands busy. Keeps my hands busy so I don't want a cigarette. Oh, thank you, Gina. But yeah, that's what I've been doing to keep my hands busy, and it's made it a lot easier to quit too when you've got something to do with your hands. So if I'm not out in the backyard doing some gardening or picking up branches that come off in these last storms or dealing with these gas guys, whatever I need to do. I've been doing my laundry and stuff and whatnot, just trying to keep my hands busy so I'm not grabbing for that cigarette. So anything helps. So these diamond paintings, I've been whipping like this one. Let me just start cam. This one, I guess. This one here is the 30 by 40 centimeter. I can do this. Whoops, I don't want to show the bottom. Okay, Mitch, you just got a quick peek at that. I can whip out one of these size. See, I don't want to show you what's on here because it's a surprise. I'm doing this for another creator. K Mitch knows who it is, so let's not say it though, K Mitch. I can whip out one of these this size in 2 days. But that's because I'm keeping my hands busy. I've done a lot bigger ones. I've done ones that take up like my whole desk here. Marie Burke says I've been going nuts on them too. Yeah, I've got quite a few done. So, but it helps with the quitting smoking. You're focused on something else. You got something to do with your hands. I think he's gonna like, yeah, I got a few things. Okay, Mitch, I wish I could show you the other thing I got, but I don't want to put it on here in case PJ comes in, because PJ's gonna see it. But there's another one that I got that I think he is gonna howl. But I've got to do some alterations to it a bit to customize it for him and PJ. But this one here is going to be, this one's going to be customized too once I'm done it and I got it cut out and framed. There's going to be some wording on the frame itself. I hope they like it. I think they will, but I could take a picture of it and send it to you. How can I send it to you? Okay, Mitch. Ugh. Okay, give me a second, you guys. Yep, that was Microsoft. there's a huge virus on my computer. I need to call them right away. And for $3.49, they can fix it all or my computer's going to lock up. Like, get out of here. Okay, I got to stop messing with that because I'm just going to mess it up. But anyway, where do you get the frames for your dog? I make mine. I'll show you how they start. So, let me grab it. Where's me? Oh, I got the other bigger. I can't bring in the bigger one. Okay, start cam again. Let's do this. See, I buy wood like this. There's 4 pieces here, and it's really, 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 like I can't even show you at all. It's really long. I use this for the corners for bracing. And then I've got other wood that's about this thick, which I do the actual frame with, and I cut my corners to make the frame. And then I use this. This is 4 pieces. These are individual pieces. They're not very thick. And I use these to brace my corners. So I make my own out of wood, and I paint them or stain them depending on which painting I'm doing. Whoops, you guys can see it. Depending on, like this one, I may paint the frame like a dark blue to match this dark blue here. And like I said, once I'm done, I cut it out. I put it on a poster board to get it like tight, measure out for the piece of glass to go in the frame also. And then I'm going to customize the top of the frame on this one. I'll customize the top of the frame with some lettering with the person's name or something. There's something that I want to put there, but if I tell you, it's going to give it away. So, oh, thank you, Marie. It keeps me busy. Like I got a little jigsaw and I got a little router and everything so I can cut everything proper. And me, it's usually I have problems with the corner, but now I've got a tool. Where is it? Here it is. I got this handy dandy tool that I bought now so I can get my corners proper for 45-degree angle is what I generally use. So now I've got one of these where I can use this to do my corners. Made it a lot easier. So that's what I've been doing. Okay, let's put this back up. Yeah, so that's what I'm doing, you guys, while I've got my other computer screen to the right of me, which I got what you guys are seeing. It's up on the screen beside me. So, and I've got my volume on. So as soon as they come back or I hear anybody in the court, text it to Des. Okay, hang on. I can show you a couple of the things that I got. Oh, no. Okay, who's this guy? Okay, hang on. Hang on, you guys. It's the gas guy again. Hang on. Hang on, I gotta mute. All right, sorry about that. Hand's making me dizzy. Okay, Mitch, are you still here? Sorry. I had to allow them in so they could restart my furnace, the pilot light on my furnace, because they had all the gas shut off. And I don't want to have to pay $125 come winter for the gas company to come and restart my what was I going to show you? Oh, I forget. This in there. All right. Oh, yes, you wanted me to text it to Des. That's it. Okay, I'm going to take a picture of it. I'll text it to Des and tell her to send it to you. The camera. I'm getting my light. Hang on. Okay. Oh, excuse me. It's because I was in the basement. Okay, let me text it to Des. Oh, okay. Why is it doing this? Okay, Mitch, I just texted to my sister so she can send it to you. That's just one of them. Plus, I'm doing the diamond painting. Plus, I got a whole bunch of other stuff in the bag here for them. But I think he's going to get a kick out of that one. You're going to see it. So message her and tell her to check her damn messenger. Okay, back to this. I was hoping actually to have more than half of this done today, but with everything else going on in the house. It's been crazy. But I will get it done this week and then get it shipped out to them. And is that the right address that you sent me, K. Mitch? For their address? Like, is that the recent one? I want to make sure it's going to the right place. There's a lot of work to get lost in the mail. Okay. What did I just do? I wonder what time they take lunch at. I think they take it from 12 to 1. So maybe just after lunch, maybe they'll come back. They gotta, if they're gonna come back today, it's gonna be before 4 o'clock, because there's a juror that has to leave at 4, and I know they're being sequestered, or maybe they're not. Are they even being sequestered? Gina says, Willow, have you heard of the Sandra Birchmore case? No, I haven't. Are they even sequestered? I think they are. They should be. All right. Come on. Next color. Let's do this one. They're not sequestered, Gina? I think they are, because they swore in the sheriffs, right? So yeah, they're sequestered. So they get on a bus and they're taken to a motel. And she said she has to be back on that bus for 4 o'clock. So is she going to have like a FaceTime with maybe a doctor, or I don't know, there's something. They have to be sequestered. Especially in this case with all the corruption that's going on in Canton. Yeah, I'm sure they are sequestered. And I forgot they swore in the sheriffs, so. And they're all being brought in by bus. So I'm assuming that's right from wherever they have them held up for after where they go after they're done deliberations for the day. Yeah, I couldn't see them not being sequestered, for especially with all the corruption that's been going on in this case and in Canton. I just hope they come back with a verdict today. We'll know if 4 o'clock rolls around and there's no verdict. We know that there's not going to be one. Probably by like 3:30. Risa says, yes, they did. They did. Plus Karen's fans outside. They did put them alone. Yeah, I couldn't see it not being sequestered, because look at all the corruption already in this case. And things that were done. I mean, I don't think the prosecution had a chance in hell. And I also,
You are unmuted.
uh-oh, 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 uh-oh. You guys,
Back to 1780.
Judge, we're back on the record on 22117. Counsel have both had an opportunity to look at the new verdict slip.
All right,
Oh.
so does the defense say the verdict slip's in order?
It is, Your Honor.
Okay.
Thank you, and we appreciate the call.
Okay, does the Commonwealth say the verdict slip's in order?
Yes, Your Honor.
All right, so the verdict slip will go in. Officer Delano, I'll let you do what you're doing.
damn it.
All right, so the verdict slip will go into the jury. I instruct you or Officer Leiden to remove verdict slip for count number 2 from the jury, have the jurors fold it, put it in an envelope and seal it. And we'll bring that in and we'll mark that for identification. I'm also going to send in a transcript of the supplemental instruction I gave this morning. May we mark that? Madam Court Reporter, please. I have copies for counsel if you'd like.
So she lied to the jurors. She said,
Yes.
I'll have that to you within 10 minutes. That's been more like 40 minutes.
Thank you.
All right, so with that, we'll be in recess. And you'll remember that the jurors were instructed that we won't take any questions or verdict during 1 o'clock to 2 o'clock. Okay.
I missed that last one.
The jurors were instructed in the instructions I gave yesterday that we will not take a verdict or a question from 1 to 2. So everybody's free to go for lunch.
Thank you, Your Honor.
All rise for the court, please.
1 to 2 is lunch, and then they'll have like an hour and a half to reach a verdict, because I think that they're gonna start wrapping it up around 3:30 because the one juror said she had to be on that bus for 4 o'clock. So that means she has to be back in her motel room for something. So, okay, so there we are. Okay, you guys, I'm going to mute for a few minutes. I got some vacuuming here that I want to get done. And I will jump right back on if they come. Well, they're not going to be coming back now until after 2. So I'm going to be muted until at least then. Oh, thank you so much, Grace Graham. And you're very welcome. It looks like we will be going into day 3. It's 2:45. I don't see them coming back today, you guys. Like I said, the one juror says they had to be on that bus by 4 o'clock because they have an engagement or something. There's something that they can't miss. So the judge agreed to end deliberations early today. So I'm assuming that they're going to wrap up deliberations very, very soon. So I don't think that it's going to, even if they did come to a decision today, I don't think it's going to be read today because they wouldn't have enough time. This juror has to be out by 4. So we're going to hang around till about 3:30, 3:45. If we don't have nothing by then we're going to call it a day. I will get the thumbnail up and ready for tomorrow and have that available so you guys can set your notifications. I'll do that at the end of this video. But thank you, Crazy Graham Ford. Thank you so, so much for your super chat. I so greatly appreciate it. Okay, you guys, I'm gonna end the stream here because I gotta go outside. These gas guys need me to show them where to put some stuff and whatnot. So I'm gonna end it here. We will be back tomorrow morning. Watch for the thumbnail. It will be up tonight as soon as I can get back in the house. It will be up. So we're gonna end it right here for today, and I will see you guys all bright early again, 8:45 tomorrow morning. Okay, love you guys. Bye bye for now.